Item number 1 and 2 for orders.
Affidavit was supposed to be filed. Affidavit was supposed to be filed.
Lordship, one of the affidavit already has been filed and affidavit has already been filed. Lordship.
Give us a copy.
If your lordships permits me,
Mr. Sharma, just a moment.
yes, very well.
Just a moment. Mr. Nath, we were wanting to know about the status of the homes.
Yes, Malad. Malad, that annexure we have given. Malad. Can you see the annexures?
No, that is vulnerable.
No, that is the second affidavit. In the first affidavit, but I have given a copy. Malad. I have handed over a copy.
This affidavit.
Yes. Yes, Malad. Two affidavits here, right? Melo chip. First affidavit. Yes, sir. Yeah, yes, sir. Lordship has seen the one Excel sheet is there. No?
Independent.
Upahana material. Annexure A. Right. Hello.
Last time you said that you are taking steps for appointing of the chairman and members of the.
Correct. And And in the affidavit, we have said in the by the month of October, my lord, this process will be over, my lord.
Completed.
Lordship.
And steps for social audit?
Social audit, my lord, we have stated in the affidavit, my lord. Kindly. Copy the degree, my lord. Palame. Diamo copy. Copy the degree.
24/8. Yes, it is social audit.
Why don't we have, we
Don't have a social audit platform at in the state of Assam. You have appointed someone from Mumbai.
Paragraph small. But the lordship, we have to get the service of the. With their help, we are doing it.
Because they have to visit, my brother has just pointed out,
My lord,
48 aided children homes.
correct.
9 are state run
My lord.
and others are run by the NGOs themselves through their own resources. They are not granting aid.
No, that position also we have stated, my lord. Lordship will find, my lord, in paragraph 3A, my lord. We have stated that
Of this affidavit.
in paragraph 3A, my lord, we have stated that the government-run homes are funded directly by the government and the functionaries are government employees under the Mission Vatsalya, which is a centrally sponsored scheme. There are a few NGO-run homes which are funded by the government under Mission Vatsalya. These homes are reimbursed as per laid down norms in the Mission Vatsalya guidelines. There is a third category of homes which are run with their own funds or
Which they run by their own fund.
lodging.
So that is, so therefore you see, if I run an institute out of my own funds, how can the government compel me to do something which is according to the Vatsalya scheme? If I'm doing it, I'm doing it on my own risk and own cost.
But
At my own whims and fancies.
they have to get registered under section 41. of the-
What is the mandate? First tell us. The issue is what is the mandate regarding the children home and whether you have complied with it?
But the entire each and every district, we must have one.
You must have
Lots.
one children home.
Correct.
Now, most of the children homes are being run by NGOs on their own. So we'll have to delete all those because you don't have any control. Some are refunded or whatsoever way you say, supported by you, grant in aid, not totally.
Correct.
Okay, assuming for a moment those are in association with government, then also situation is pathetic. That is what we wanted to know. As simple as that. What are the government runs? And that too by sponsored by central government. Now central government will have to answer what is their scheme for sponsoring only for these 5 districts or they are having a responsibility to sponsor other districts. These questions are to be answered.
But because of
But
this
then, Mr. Chaudhary,
Matlab,
then,
because
Mr.
of this
Chaudhary,
situation and
you will also have
incident
to
that-
file an affidavit saying about the scheme and whether
Compliance
this is acceptable to you or not.
Worship, I definitely respond to that. Take a copy from him and insert the copy of the affidavit.
We'll hear Mr. Sharma
Yes.
so that we can throw some
Because
light.
of this logjam, entire process.
Just a moment. Let him-
Lordship,
Yes, Mr.
Wait,
Sharma.
please, Malad. Malad, first of all, I have just now emailed to the court master a 6-page note, my lords. The one that I had handed over to my colleague, Mr. Nihal Chaudhary, my lord. That is slightly outdated, my lords. The 2 points were missing. I have just emailed. If the court master can take a couple of copies, my lords. I'm so sorry. I'm not available to hand over it myself. That document of 6 pages has dual purpose, my lords. One, it will probably help your lordship. It is my attempt to help your lordship, assist your lordships, my lords, for the conference that is there on Saturday and Sunday. Purpose one. And also, my lords, if these points could also be considered by the state government to be incorporated and implemented in the state of Assam, we can be the pioneers and the first movers as far as this is concerned. I am sure my learned friend representing the state also doesn't have copies of it, my lords, because it was emailed just about 5 minutes back to the court master. That is point number one. Point number two, my lords, is the issue of the social audit, my lords. My learned friend has still not mentioned, as far as at least I don't have a copy, I'm not privy to the copy that my learned friend reads. My lords, social audit is paramount, my lords, and let that be done, my lords, within a time-bound period, immediately, my lords, because there, my lords, as in Hindi it is said, my lords, doodh ki doodh, pani ki pani, my lords. Everything will be clear as to what is happening in the state of Assam as far as child protection law is concerned, my lords. So therefore, immediately, what is paramount to be done is the social audit, my lords. Rest of the things pursuant to that will definitely follow. And your lordship was, I'm so grateful for having put that in the order, my lords, last order, about formation of a committee. So the social audit and the committee, my lords, together will give a lot of options to the lordship as to what various steps needs to be taken going forward.
But the last affidavit, what I am reading, that has been emailed yesterday, and my friend possibly he's having the copy.
Okay.
I will have a look at that, my lords. I'm so sorry.
You
Email
wanted
has
to
been
say
sent
something?
yesterday.
You wanted to say something?
This mechanism of running childcare institutes by the NGO has both pros and cons, my lord. One incident that we witnessed in a Shivsagar home.
Shamak,
Use your mic.
But I may be allowed to call for both the affidavits. The requisitions.
definitely.
Look, one incident that we came across in Shivsagar home, pursuant to which, my lord, a Sumoto PL was also registered, wherein the superintendent of the child care institute was involved in harassment of the child, my lord. And it was, my lord, the facts are very annoying, my lord. This court took cognizance of this. Look, these are, my lord, it appears that state, I'm sorry to say, my lord, state is now trying to implement the provisions of the act, my lord, now. Vis-a-vis, if we compare ourselves with other states, not to speak of the other countries, Lord, we are in a very low pedestal, my lord. I'm sorry to say, my lord. And what social welfare department is doing, my lord, they best know, my lord. What they are doing. My lord, I have seen the affidavit, my lord. There is nothing. Five queries, your lordships raised, my lord. There is no authentic material before your lordships, my lord. This is how things are going on.
Mr. Mazumdar, can you come forward?
Yes.
Mr. Mazumdar will require a very elaborate plan of the state, because now what we are finding is that, as my esteemed brother has already said, you see, unless you tell us regard to the nature of plan which the state has for the children homes, number one, the source of funding, the management, he has, Mr. Das has put up a issue about the Shivsagar homes. So this leads to the only option we have is to issue a direction for two things. Number one, the committee has to be constituted with full strength. That is number one. And number two, the social audit has become a requirement which is very essential now.
My lord, we have already written to a Mumbai-based Angan Trust to conduct a social audit on the 12th of this month. We've already written to them. We have requested them to come over and visit each and every one of the 93 children homes that are in existence under the JJ Act. And they have assured us that they will be coming and conducting a social audit of all these 93
We
child
don't have
homes.
good institutions here to do the social audit in the state. Then why we don't engage our own people?
The guidelines
Because you
say that
see-
it's third party.
Huh?
The guidelines state that we should engage third party organizations.
No, organization in the state can be also a third party.
Yes, my lord.
There's no requirement that third party means a third party from a different state. Because if we have people here, it will be easier for them to travel. They know the, what you call, the terrain, they know the nature of, what you call,
The circumstances.
the area and circumstances also. It will be easier and faster for them to do it.
We'll
You
have
see,
to look for
we don't have anything, we don't know about this trust. But you see, people who are coming from places which are more commercial than us, for a Bombayite to come here and do the audit, I don't know. I have some reservations. If the reservation is without any justification, but you see this, the infrastructure which the Bombay has, with that perception, if they come here, with they have to travel so much and then do the audit. Cost involvement would be very high for the state. So that's why we are suggesting, nothing against any particular person from any state. We are not
I think it
making
might not.
any,
I'll explore-
adverse
I'll
comment.
explore the possibility if there is some organization in Assam.
No, if not, you can train them, because you see, the audit is not something which you are doing, is for the first time in the world. You have the parameters, you have the check notes. It can be shared and you can train people to do it. And I think there will be good, trustworthy people who will be available in the state to do it. And this committee for monitoring, do you have any suggestions?
My lord, under the Mission Vatsalya guidelines, we already have a committee in place. That is the state level committee, state level Child Welfare and Protection Committee. And in that committee, there is a provision for co-opting domain experts. In fact, whenever a meeting of this committee is called, we generally call upon domain experts to join us during the meeting. So I have enclosed a copy of the notification in the affidavit.
10.6 Annex C.
No, you see, in the last order we have said, it is also suggested that the court may appoint a committee consisting of the learned senior government advocate, officials of the Department of Women and Child Development Assam, NGOs working in this field, as well as the petitioner or a representative to visit various children observation special homes in the state, and also to monitor the implementation of various child protection and or child right laws, so as to ensure that the directions contained in the case of Sampurna Behura is complied with. So you see, not only your own mechanism, not only your mechanism, but we are requiring a compliance now. The committee must be there to ensure that the directions in Sampurna Behura is complied with. So we have already given a suggestion here that the senior government advocate or his representative, your officials, some NGOs working in the field. So, as well as the petitioner or the petitioner's representative, so that not only you do the audit, but let us have the, what you call it, is just like a inquiry being done by the court, because since we are monitoring it, they will directly report it to us. This will be court appointed committee. It will be court appointed committee. So you, on the next date, you give suggestions of the names, few names, so that we can have a consensus and then appoint them. Mr. Sharma, you also give us
Yes.
suggestions. names.
We'll also give names. Malaj, we have a state coordinator also, Malaj, who can also assist in the committee, Malaj, going to different places. I have already taken consent as far as that is concerned. If the state government deems it fit, the state coordinator will provide.
Because this is a court required committee,
Right, Malaj.
so the state will have a very limited option to oppose it.
Correct.
But it will be our decision to appoint committee members.
Very well, Malaj.
You give
We'll
us
be happy to assist, Malaj, and we'll offer complete whatever domain knowledge my clients have, Malaj, they will pour everything out, Malaj. The two more aspects, Malaj. Two more aspects. I'm so sorry, Malaj. Lordship was going to. Malaj, one, the child protection policy, which is required under the Act and the rules, Malaj, has already been drafted. For some reason, that has not been notified as yet. So also, the status of the JJ rules, both seem to have been drafted, but none of them have been notified. Malaj. What happens the moment these two are notified, Malaj, and Lordship had indicated they are still going under the model rules. When the state has already notified, why should the new rules already drafted? Why should the new rules not be notified? That's one. Two, the policy is important, Malaj, because policy contains a lot of Malaj issues. For example, what is to be done in the schools as far as the children are concerned. All those guidelines are there in each of the policies. Other states have. The state has also drafted. All it should do is to just notify, Malaj.
Can I respond to that?
Yes, yes.
I had spoken on the previous occasion also during that meeting, because other departments are involved. We have to consult education department on this. We have to consult Panchayat and rural development on this. So we have to send the files to various departments for their comments on the policy as well as on the draft rules. So it is in the process of being circulated. It has already been circulated to the other departments. We are awaiting their views. Once their views are received, we modify our policy and
Then
notify.
we'll implement those two departments and ask their representative to be present through their learned council so that we can monitor that also. So if there's a policy which is in circulation, and if the circulation doesn't end.
One more thing to counter my learned friend, Malaj. I'm not countering it because it's non-acrimonious, Malaj. But the whole these laws have come into force in 2016. In 2023, if you are saying that we are still discussing amongst department, Malaj, I mean, there's much to say, Malaj. I mean, I'm sorry, I'm not saying anything more beyond that, Malaj. We are almost 7 years away from the date of the, enactment, Malaj.
But must stop somewhere. So Chaudhary, you'll have to respond by when? Within 2 weeks?
That is,
And Malad, one of the query.
Because we'll take it up after 2 weeks. So within 2 weeks, you file it.
yes. What is the funding pattern and how it is being monitored?
No, not only that. You see, you'll have to also bring the policy into
Yes.
on record. The policy is to be brought in. Then the what you call that, some sort of vision document. Because if you are funding, you must have a vision why you are funding it.
Yes, I understand.
It's not just a dole out. You must have a vision to fund it. And then when you are funding it, you are also monitoring the expenditure.
Yes,
So all three aspects, because otherwise we are in the what you call same spot.
yes.
Just like Mr. Sharma said, 2016 and we are in 23, we are in the same place. We have not proceeded. And Mr. Das is saying that we are in a very low pedestal. That should not happen. This is not an adversarial litigation. We are not we are not making any adverse comments against the state, but the state must do something more.
Correct.
And if the government is funding it, they should also see that it is implemented. Because we have all seen at some point of time, policy means you have a policy. The first thing is that the chairman has to purchase a car. Correct. So at least when you are funding it, you must know where the money is going. And if you know it, we should also be informed where the money is going. And number two is that you will also suggest the names of the government officials or your representatives who will be assisting the committee. It's almost like a fact-finding committee. We must have a representative.
In fact, what I was wondering, I myself would have liked to be in that committee. Let's see.
No, it's welcome. But you see, you have more business here.
Yes, that is what I was.
So it's your choice if you can assist. That's what I'm saying. You see, I have named a senior government advocate or his representative, because what happens is that at times you may think that your service to the society is, for that you can spend some time. So on that day you can
Yes.
give a shramdan for a good cause. Achha.
Not one suggestion, this honorable court by an order dated 16/5/2023 involve UNICEF into this matter. Pursuant to that order, my lord, a representative from UNICEF also, my lord, appear personally and tried to assist this honorable court. Lord, my only prayer is that if that representative from UNICEF can also be included in the court appointed committee, perhaps that may help.
So give a proposal, because you are asking for names.
Yes,
You
my
can
lord.
suggest a name.
Yes.
And when you are suggesting names, please also take his consent.
Yes.
Because it's not that
Definitely.
we collect the names first
Yes.
and then we ask them for their consent, and then
Yes.
they say we are not consenting.
No, that's consent.
So
is to-
we are
I'll have a
we
talk.
are
and-
expecting that when you are giving us names, that you have also
Definitely.
taken the consent.
Yes,
The
my lord.
consent.
Yes.
And well, the this first affidavit is not containing the information regarding 6C, direction 6C as regard the status of VWDC. In the second affidavit, we have taken the status. The VWDC status.
Not
Not-
being the senior government advocate, you
Malad.
can take the initiative regarding the coordination between the departments.
Correct.
Because this we are listening from many a times,
Malad.
that these policies are not being formulated for the reason that there are many stakeholders. But how far? There must be a deadline.
Correct.
Isn't it? It's a mandate of law.
Correct.
You have done your part, but not implementing because there are many stakeholders.
Got
Don't prove one again and again that Assam is a land of lahe lahe.
Malad, we'll explain.
Retaking the order, but will
Yes.
reframe it.
I think Malad, that affidavit status is before your lordship. The VWDC status. The first affidavit lordship was holding, in fact, it was the second affidavit.
Huh. VWDC.
Lord,
Mr. Nath, just like the presentation Mr. Sharma had done on the last occasion,
Lord.
giving a comparison. So if you can have a chart-wise presentation
yes,
instead of the affidavits, it will be easier for us to understand. Because you see, Mr. Sharma has painstakingly penned down his suggestions.
correct.
And the points he's trying to raise. He is so that we now don't have to go through all this heap of documents.
Lord,
That presentation was very good. So in
Lord,
fact, in extension to that, if you can give a response parawise, don't go for an affidavit. It will be basically your compilation of the reply notes.
Mark.
So that what we do is that we dispense with the reading of all these documents, and we have a bird's eye view of what we are dealing with.
that move.
Because right now we are flagging up only 3, 4, 5 issues.
Lord,
We have not gone into all the gamut of points which are required to be addressed under the Sampurna Beura case.
Lord,
So because we are trying to simplify things so that one, point we close it and then
Then
open up
we
the
do
next
Logical.
point.
Correct.
And Mr. Mazumdar, from the next day onwards, send some representative from the government to the court in this matter.
Right.
So that at least there should not be a communication gap between the government and government advocate and your department. Implementation will be faster then.
My lord, to the extent possible, I'll remain present.
No, we are not, you see, we know our secretary would be extremely busy. So we are not issuing any direction, commanding you to be here. But what we are saying is that you or your representative ensure that somebody is at least here.
I'll ensure.
Well, from the affidavits so far filed from the government by a judicial department or social welfare or ASCPCR, well, I'll from those affidavits, whatever information has come, I'll put it in
If
the.
required, you from the court master, you give a slip and take it and then do it, because this is not an adversary litigation.
Correct.
What we want is an implementation of the
make
child rights.
That's true. That's true. I'll make a note, whatever information has come now, I'll put it.
Because here we are not requiring for the time being, because now we are trying to pinpoint those issues and we are taking up the
Logic.
matters.
Logic.
Right now, we are not insisting on an affidavit.
Not particularly, and in that issue, whatever we have said so far, that I'll indicate in my note.
The affidavits which will be required will then issue a direction for an affidavit when compliances are required.
Madam.
But right now, we are trying to summarize these issues
Done.
and what do you call go issue wise.
Madam.
So for the time being, we are not insisting on the next date. We are not insisting on an affidavit. But what we are trying to know that we have the government's view, the views of the Mr. Das here, then Mr. Sharma and Mr. Chaudhary here, so that we progress. We are right now with this litigation from 2018. We are still in the same place. We have not inched forward. Where we started in 2018, we are still there. The progress we are not noticing.
It's
The impact of the litigation on the progress of the issue, which we are trying to take up. We are not finding any progress. Heard Mr. P.P. Sharma on council through video conferencing, along with Mr. N. Chaudhary, London counsel for the petitioner. You can take a seat, Mr. Mazumdar. Take a seat. Also heard Mr. D. Nath, a senior government advocate, appearing for the state. As well as Mr. P.P. Mazumdar, Leonard. Secretary to the Government of Assam Social Welfare Department.
now it is Women and Child Development.
As a Women and Child Development Department. And Mr. H.K. Das, Leonard, standing counsel for this court. Next one. Referring to the order dated 19/9/2023, the Learned Senior Government Advocate has submitted that 2 affidavits have been filed for 2 affidavits filed. One to cover up the points raised in paragraph 6, A to D, A to C and E.
All other except C. Others except C.
Except C, okay. A, B, D, E. And the second affidavit is to cover the point raised in paragraph 6, C of the said order dated 19/9/2023. The registry shall tag the said affidavits on record. Next paragraph. In terms of the order dated paragraph 7B of the order dated 19/9/2023, The court is issuing a direction to the state to suggest the names of the officials of the Department of Women and Child Development, along with alternative names and the representatives of the names of persons engaged in the non-government organizations working in this field, out of which we would be appointing 3 persons in the committee. We also request the Learned Counsel for the petitioner as well as the Standing Counsel of this court to suggest names for appointing persons in the court appointed committee. As indicated in the previous order, we said court appointed committee would be engaged to visit various children of the observation of the special homes in the state and also to monitor the implementation of various child protection and of child right laws, so as to ensure that the various directions contained in the case of Sampurna Behura versus Union of India 2018 4 SCC 433 is complied with. Full stop. The names should be provided by way of a list to be filed with the registry for being tagged with this order. How much time you would need? 2 weeks? Within 2 weeks, names will be given by way of a list. Next para. The Learned Counsel for the petitioner on 24/8/2023 had provided a compilation of 11 pages. First one, the learned senior government advocate shall present a compilation of reply or suggestions on those on the points which is raised by the learned counsel for the petitioner. Which may be filed without a requirement of any affidavit to support the said reply. Next para. In course of deliberations, the learned the Secretary, Women and Child Development, had submitted in response to the submission made by the Learned Counsel for the petitioner that the state has drafted the juvenile justice rules as well as the what do you say? It's a policy.
Child protection.
Child protection policy.
Child protection policy.
Child protection policy. However, the same is being circulated to various departments for their suggestions and comments. First off, in this regard, the court is of the considered opinion that the Juvenile Justice Act was, in the present form, was enacted in the year, which is the year Juvenile Justice
2016.
16
Act of 2016.
to the 2016,
It's 15, but
15,
15 and notified in 2016,
16, Act 2 of
16.
16.
and therefore the delay in framing of the notifying the rules and the child protection policy is not at all appreciated. Full stop. Under such circumstances, the court is inclined to request the Chief Secretary of the Government of Assam to take steps so that the various departments and agencies who are required to be consulted before notifying the juvenile justice rules and the child protection policy by calling a joint meeting and or to otherwise otherwise monitor that the suggestions and comments of the other departments are obtained within a specified time frame of 4 weeks from today. First off, the stated purpose notice that in the event the comments and suggestions from the other departments who are to be consulted are not received by them, the court will be compelled to impede those departments in this litigation so as to ensure that the directions contained in the case of Sampurna Behera within bracket Supra is complied with within a time frame. Full stop. Accordingly, the learned senior government advocate shall transmit a copy of the order to the Chief Secretary of the Government of Assam for his information and for doing the needful to liaison with all the offices to for compliance. Next para. The Union of India is stated to be funding a part of expenses required for the maintenance of the juvenile justice homes. No, sorry, it will be children of the observation of the special homes and for implementation of the case of Sampurna Behera within bracket Supra. Full stop. Therefore, the Union of India shall also file an affidavit to bring on record, number one, the policy in force through which they are funding the these homes and other child welfare activities, child protection activities. Comma number two, the details of funds which they have already dispersed. And number three, audit or compliance reports, if any, collected to ensure that their funds provided have been properly spent. The learned DSGI shall send the download copy of this audit to the concerned authorities for compliance, and also to obtain the names of representatives to be in the court monitoring committee as indicated above. The said affidavit shall be filed within a period of 15 days from today. Full stop. All the councils are carrying the matter shall exchange their the filing whatever they have made with each other, so that on the next date of listing, all the stakeholders are prepared to make their submissions in the matter. Next paragraph. Court permits the Land Council and the government officials, if any, wanting to address the court by way of video conferencing. So your officers can join us by video conferencing on the day. Next paragraph. The Secretary to the Government of Assam, Social Welfare, Child and Welfare, Women and Child Development, shall depute one of his officers to be in the court when the matter is listed next. List on. Now suggest a date.
Well, since this is a special bench, your lordship's convenience, Malad, whatever the registry deems it fine, Malad. I will be there, Malad.
Okay. Anything we have left out in the order? Discussions we were having, anything left out?
The social audit.
Social audit. Achha, yeah. The Secretary to the Government of Assam, Social Welfare Department, Women and Child Development Department, has submitted that they have taken steps for appointing a audit for appointing what is it organization?
Angan Trust.
Angan Trust to do the social audit. The Government of Assam shall ensure that the audit is commenced as expeditiously as possible, and whatever audit is done prior to the next date of listing shall be placed before the court. The report of audit done
This,
prior to the next date of listing. Yes.
Malad, what I have been just briefed is that in Maharashtra and a lot of other states, Tata Institute of Social Sciences also does this social audit. So I don't know the authenticity or the veracity as far as this particular trust is concerned, but my state may consider appointing Tata Institute, Malad. It is a well-known organization, Malad, and probably cost-wise also it will be very effective, Malad. It is only a suggestion, Malad. It is for the state to consider.
We have TCR. We have TCR. We have TCR.
At this juncture, the learned counsel for the petitioner has given a suggestion that, as per his information, what is the name?
Well, Tata Institute of Social Sciences, TIS.
Tata Institute of Social Sciences also does similar audit, and they can also be explored for doing the audit. It is for the state to take a call on this suggestion. It will be here over there. audit shall be, the expeditiously or the audit shall be done, and then the report done so far, that sentence will come here. So we are directing that the expeditiously should be expeditiously done, and whatever audit is done prior to the next date of listing shall be placed before the court. This one.
In the last totem, there was a direction 510, my lord. Detail affidavit to file, detail affidavit by 510. So after
No,
that.
it is to be 510, but we have not fixed a date.
Yes, no, date was not fixed. my lord. So it has to be after
Now,
that.
now, my lord, in view of today's order, Lordship has directed us to give us a note, my lord, in response to whatever as petitioner has filed. So that instead of the detailed affidavit, we will say our response in that particular note. my lord.
Yes, yes.
Lodge.
We have exempted, in fact, we have,
Lodge.
by judicial order, we have exempted
Lodge.
the affidavit.
Lordship.
So then we do it on 10th of October.
10th.
Next date is 10th of October.
Lordship.
This matter on 10/2023.
My lord.
10/10.
Very good.
10th is a Tuesday.
Just, I don't know.
But
Yes.
the state, from the state legal service authorities, they used to timely visit these particular homes and they used to prepare some reports. Those reports can also be called for, or Lordship can have a look at on the reports, what they have found.
We'll inquire in the administrative side, and then
Lot.
if available, we'll take it.
Lordship, some indication that will indicate something. Mother.
Otherwise, you see, when we are calling the reports, we are burdening this files also.
True, mother.
So because they you see every because we are not aware of the nature of the reports they are making for on this home visit, because they have their requirement is to see that they are given legal assistance. Perhaps their duty is not to see the functioning of the homes.
But they used to see how the homes are functioning. Anyway,
We will see to it. We'll see to it.
Lordship report will indicate.
We'll see to it.
Lodge.
We'll ask the.
One or two report Lordship may call for and see how
We'll
Lodge.
on the
Yeah.
administration we can take it up and
Lodge.
we can have that.
Because
reports.
nowadays not a jail inspection, home inspection, those are being done continuously.
No, but the purpose of their, you see, legal service authority, their purpose is different. Their purpose is not to monitor the functioning of the homes. They will be visiting only for the purpose of knowing whether they are requiring any legal assistance and to provide. Because the government otherwise doesn't fund them for anything else. Their funding is limited to the extent that they will go and do their work. So, and their work is also again monitored by the Supreme Court aided committee. So right now we are not passing a judicial order. We'll have it.
Just
from the
I'm
administration, we'll have
I'm
it
indicating
done.
one or two maybe
We
looking.
will get it.
Lodge.
Don't worry. On the
Lodge.
next date we'll get it.
Lodge.
Your Lordship has got the 6-page note, Malaj, on conflict of law, Malaj. The
Yes,
six.
we have got it.
And,
Yes,
and
also-
I would request that a copy I'll collect from the court master. A copy Logic. That note will help.
This is with regard to permanent alimony granted to the wife. My friend came up with a suggestion that if for once this matter can be sent for mediation and something can. Oh, it's on mute. I'm sorry. My friend came up with a suggestion, if this matter can be sent up for mediation once, and if something can come out from there.
You suggest a date when you can come, both of you.
Any date the court fixes. Both of them are from Guwahati.
Both of them are from Guwahati.
Yes, they can actually.
You suggest a date, we'll send it on that day. You agree to a date.
She is white. So, her convenience is required. No? She is lady.
9th or 10th of first week of October, any date.
First week.
My lord.
Okay.
6th of October.
6th. Okay.
6th of August. Fine.
In favor of the respondent. And the said order has been assailed in this appeal. Next paragraph. It appears to the court that in this matter, there is a chance of a negotiated settlement through mediation process, being a family dispute. First off, the learned counsel for the parties have also suggested that they are agreeable to the resolution of the dispute between the parties through mediation. First off. Next, accordingly, the court is inclined to fix the date of 6/10/2023 for the first sitting of the mediation in the Guwahati High Court Mediation Center at on 10, at 11 a.m. At Guwahati High Court Mediation Center. First off, let a copy of this order be sent to the Guwahati High Court Mediation Center to facilitate mediation by appointing a trained mediator to mediate the dispute between the parties. First one. Personal notice, as both sides have agreed to mediation, issuance of notice to the parties is dispensed with, and if required, the learned counsel for the parties shall provide a downloaded copy of this order to the parties, which would constitute due notice to the parties to attend the mediation proceeding at the appointed date and time. First off. Let the report of mediation be placed before the court on next is our vacation
Puja
on
is
10
after
10,
vacation.
11.
Lordship will keep after vacation. If
10, 11.
mediator thinks that or
10/11
yes, ma'am, fine.
10/11. We start 10/11. 10/23.
Mani, highly appreciate. Highly much appreciated.
This matter relates to POCSO Act, whether live streaming.
As far as bail application, I filed my objections on record, but if your worship wants the presence of the PW2, Because the services of notice, was it?
It has to be completed.
Yes, yes, it was mother of the victim.
The office note says that no steps taken, no notice could not be issued.
Oh,
I'm sorry, I will take within 2 days.
So you also take, she will also have to take.
oh, yes,
I
I'll send
think-
it.
Mr. A. Ahmed, counsel for the appellant. This is an IA.
Aye.
Then in appeal, you right, so and so. And Ms. S. Jahan done it, APP for the state. As the paperwork is prepared, let the matter be listed for hearing. In the month of December 2023. No, IA, right? Achha, no, not that. Here or this. It is. Strike it out. Not if a paper is prepared. Stop. It is noted that as per office note dated, it is noted not required. Just say as per office note dated 19/9/2023. From the steps has not been taken, for which notice on respondent number 2 could not be taken. So accordingly, the learned counsel for the appellant shall take fresh steps within 2 days for service of notice on respondent number 2 by registered post with AD. Next para. The learned counsel for the petition for the appellant shall also provide a scanned copy of the memo of appeal with all enclosures to the registry, along with the return of notice, which will be processed by the registry and provided to the learned APP for onward transmission to the respondent number 2 through which police station?
This is Tamulpur.
Tamulpur Police Station, from through the officer in charge of Tamulpur Police Station. The notice is made returnable on on 13/10/2023.
1310, Lordship.
Oh, shit, today is 22nd.
If he gives me a soft copy, I can send the
We
copy.
said that.
Yes, today itself via email to the Tamulpur police station. That I
We
can
can give
do
you
it.
directly or through the registry.
Through the registry, perhaps it will take some time. If you can send me directly, I can send
Okay.
it.
Yes, sir, I will.
We give it.
Then Lordship can fix a shorter date.
Because you're taking by registered post also.
Ah,
So in case you some mishap at your end, at least register post to be served. If some mishap at your end, then the next paragraph, right? The in the event the notice is being served by the officer in charge of Tamulpur Police Station, the said authority shall take note of the provisions of what is that? Adult
oh, yes, 64.
section 64 CRPC
Otherwise,
Right.
mother is the informant.
read with
But mother, they can serve, provided they don't get the informant, then they'll have to serve it too.
Mother is the informant here.
Mother is the informant here. There is no problem as regards.
oh, that can be done.
Huh.
There's no issue.
If the mother is not found, then of course male member.
That in the event the respondent is not found, for service of notice on respondent, the said authority shall take note of the provisions of section 64 of the CRPC, as well as
Guwahati High Court.
rule 2.
Lordship had dictated that day. Rule 2, Rule 6. No, no. Chapter 11.
Rule 2 chapter, rule
2 to 5. Rule 6.
not 5.
Rule 6.
6.
Rule 6 of chapter
Mm.
11.
7. 2 to 7
Acha.
of chapter 11, of part A of the Guwahati High Court Rules and Orders. And shall ensure that the the service report is returned prior to the next service day. List of 13/10/2023. And the I also like the same thing. Notice to be served on another 2, same manner. This also had in the head so the learned APP has submitted that objection in this application has been filed, which is available on record. Then you write issue notice and so same thing.
Right.
Scan copy you give to her. Yes, item 3 is your state appeal.
This is the state appeal against acquittal. This is that matter where the superintendent of the NGO is involved in sexual offences against one of the girl child. This is what was the council was telling on the last occasion, I mean, in the previous matter.
Huh.
Here, of course, the steps were supposed to be taken upon respond number 2. The appellant, the counsel who was appearing initially for 1 and 2 both, had said later that he is appearing only for 1 and 2. He's not been able to contact. Now I have taken steps, but then it's not shown in the office note. But I have the acknowledgement. Our office have taken the notice. I mean steps on 8th of September 23 on petitioner number on accused number. But here both the accused is written. But I've told him to take it on respondent number 2. That is not reflected in the office note.
Who will permit you to send it to the officer in charge of the police station?
Not sure. Yes, that would be better. I'll take fresh steps then.
As John on the APP. And this.
Admin Konya, correspondent number 1.
Correspondent number 1 after that. The next the learned APP has submitted that on 8/9/2023. She has submitted steps for service of steps for the registry for service of notice of respondent 2. the office note does not indicate service of notice on the issuance of steps on respond number 2. Next para. The court is inclined to direct the under APP to send a notice as well. There is a scanned copy of the memo of appeal for to the officer in charge of which police station?
Sivsagar.
Sivsagar police station
Sivsagar.
for service of notice on respond number 2. Full stop. The same thing. The officer in charge will take note so and so.
I'll send a soft copy via email.
The notice is made returnable on 13/10/2023, list accordingly.
Obliged. This email thing has made the things more simpler.
No, I don't know, but we must see it effectively being
This is what,
implemented and served.
this is of course, time will show. There's a mistake on my part. I had sent him order of your lordship to the jailer little late. In the meantime, the jailer was transferred, new jailer has come. So if I may pray that your lordship will take it up at 2. I've again spoken to the jailer in the morning. So he said that he has got the, actually he has prayed for bail in respect of the old lady. So he said that he'll send the medical report as soon as possible.
Okay.
He
At
has
2 o'clock.
at 2 o'clock.
Okay.
Lodge. Miss Bhuya has actually submitted the written objection here. She is in court 1, few criminal appeals are listed there. So if your lordship takes it up after some time, she'll be back by then.
Okay.
Six.
Office note it has, yes.
My lord, as per office note dated 19/9/23, my lord, service report in respect of respondent number 2 is awaited, my lord.
Here also you take steps. This is FOXO again.
Lordship, yes. I'll take steps, yes.
Miss,
Haju Police
N.
Station.
Nasrin, my lord, on behalf of Mr.
your name,
N. Nasrin.
and Nasrin, counsel for the appellate is present. And Ms. Ajhan and the APP are present. As per office note dated 19/9/2023, answer notice and ID card has not yet been received after service. Stop.
What's that?
As the appellant has been convicted amongst other under FOXO Act, the court is inclined to direct the learned counsel for the appellant to provide a scanned copy of the memo of appeal and return of notice to the registry within 2 days for service for onward transmission of the same to the learned APP for service of notice on respond number 2 to the officer in charge
Hajo.
of Hajo Police Station. Footstone. Next paragraph. The officer in charge of Hajo Police Station, same. What is his name? On 13/10/2023, list accordingly.
এই মাত্র পঠাচ্ছি। Gotcha. I'll take this steps.
You give a scanned copy to her for the registry so that she will send notice.
Gotcha. Nice now.
7.
7 here also Lordship has called for the medical report. I have mailed it. Lordship
It
can
has
just
come.
see.
It was here.
It was here. Acha, acha.
কোনটা খালি বেশি বলি কি ফার্স্ট paragraph ফার্স্ট কেস তো তাতে বেশি বলি কি
Oh, I also got it through mail, so I'm sending.
no,
Back.
printer was placed before us. I think I have sent it to another file.
Oh, it will be there, Lordship, the same things.
My lord, my senior AC block officer is on legs in court number 2, so may
Just
kindly
let
pass
me
over
have
what
it.
He's saying that he's suffering from back pain and not very severe, it seems. He got him treated by the AMC doctor. He was examined and necessary conservative treatment was given at jail hospital. Then he was referred to AMCH on 29 for further evaluation and treatment. Now he is provided the treatment as provided.
Okay, let Mr. Buragwahi come down.
Lordship. Low backache, a loss of appetite. I couldn't read this. No so and so / O. Melina dysphagia.
No history of
No history of
dysphagia,
yes.
Marina.
Melina, yes. Bowel regular. So BP is also 110/70.
Okay, let Mr. Buragwahi come.
Lodge.
Yes, Mr. Chaudhary.
For hearing item number 8 to 12.
Yes.
I already.
Today you are looking more confident. Yeah, your face radiates your confidence today.
My lord, he is always confident. Just now, my colleague was saying something like criminal case. I reminded him, you don't underestimate him. He will always come up with something. My lord, before I have already read to PW 11, my lord. Today I want to read PW 4, my lord, again, my lord, because PW 4 is the eyewitness, my lord, in this case, my lord. Your lordship kindly look to the page 15. Before is 15 miles. Let's cut it, man.
Mr. Chaudhary 1 and Mr. Chaudhary 2. We are apprehensive. This batch may not be continuing next week.
Next is other bench has been Honorable Justice Michael Jotham Kumar.
So we will have to keep it parted. So that will happen only if you agree.
No, that is all right. It's
All right, man.
it's not an issue with us, Lordship, but we can continue in the, perhaps in the other week, Lordship will be there.
Baki kita feel good.
No, we don't know. Tomorrow is uncertain. We don't know about tomorrow. We are not even
Next
certain
week-
about
next
today.
week Maybe.
We are not
maybe-
even certain for today. Tomorrow is yet another day.
But so far as Lordship, both Chaudharies are concerned, Lordship, I can assure your Lordship, we are not into bench hunting. Any court it comes up, we are comfortable.
Okay, okay. Then you may proceed. Huh?
That's fine. PW4 my lord. S15 my lord. Today I have appeared for receipt of the summon from the court. He was called on 15/6/2016 my lord. That is important my lord. And my lord, when the incident took place my lord, it just took place on 23/12/2014 my lord. In between my lord, 18 months has been elapsed my lord.
Pardon me, we don't get the point. Please repeat
Yes,
again.
The my lord evidence has been recorded on my lord
15/6.
15/6/2016. Incident took place through 23/12/2014. In between my lord, 18-month period has been over. And my lord, I was in judicial custody from my lord, in this case. I was shown arrest in this case in 22/2015. I was shown arrest. Earlier, I was arrested in another Biswanath Sariali case. That I have to look into the record, my lord, whether it is available. It's for my partner. My humble submission before your lordship is that, my lord, despite I am in custody, my lord, and my lord, 161 was recorded, my lord, within my lord, I will come later, my lord, within 6-7 days, my lord. Despite of that, my lord, TIP was not done in the instant case, my lord. I am giving some decision of the apex court, my lord, later on, my lord. It was 161 was recorded, my lord, 3/1/2015. Like my lord, next my lord, on 23/12/2014, two borough person entered into our house. As per my lord PW4, that two borough person entered their house, my lord. Meaning thereby the incident took place inside the house, my lord, with gun and wanted drinking water. I will come later on, my lord. PW40 has said, my lord, who is staying in front of the house of the my lord, the PW4, that he saw two borough persons shoot down the Kati Hemram, Konom Hemram, my lord. Konom Hemram, my lord, in front of his house, my lord. That, my lord, place of occurrence is something different, my lord. I will come PW40 immediately after reading my lord, PW4, my lord. Drinking water. Before we could give them drinking water, one of them shot my elder brother. Name was not mentioned, my lord. That is important, my lord. Who subsequently died on the spot. Name not mentioned, my lord. When my mother tried to flee, he also shot dead my mother. Mother also died, my lord. And in fact, if your lordship go to the, my lord, that site map, my lord, nowhere it is stated body has been recovered inside the house of the my lord PW4, my lord. I will come later on all these things, my lord. I also have bullet injury right side of my head, but I was treated at Tezpur Medical College Hospital. The witness showed a mark of bullet injury on his head. I had seen the assailant, whom I can identify if I see them in the court. The witness looked at the accused person, other person present in other court, identified one person whose name is found Ajay Basumotari. That is my lord, first time, my lord, identification was made before the court, my lord. And last time I have shown your lordship on application filed by the accused person, my lord. In that application, 4 person has categorically stated that Mia people has identified them to the PW4, my lord. If I go, your lordship go to the order passed by the court, my lord, very mechanically, my lord, inquiry has been made. Because, my lord, if he state that my staff said these things, my lord, that is not available in the record, my lord. Statement of his staff, my lord. That meaning thereby that someone has said, my lord, he said that this thing has been happened. Actually, it is not correct. That statement is not there, my lord. Because it is a very serious matter, my lord. Your witness has been tutored. If your lordship go to the order, that particular order, nowhere is there. He has not mentioned the name of the staff also. Name of the, my lord, near people also. And as I have already argued, my lord, there are some advocates also present. Not a single statement of the advocate was not present and not given any explanation that there is no advocate is present. That is why I am not taking the independent advocate statement before my lord of that inquiry, my lord. That is my first submission, my lord. May I read that order, my lord? I first PW, I complete the PW4, my lord. I have
just tell me, I have referred to Exhibit 4 in my notes. What is Exhibit 4?
Yes, my lord. Medical legal report, Tezpur Medical College Hospital, my lord. Well, my lord.
This was proved by whom?
It was, my lord, Kati Hemram, my lord, the injured person.
Kati Hemram, this is PW4.
Yes, my lord, PW4, my lord. This is page 613. Then cross part, my lord.
This one, PW4, where is stated that?
Oh, my lord, in PW4 did not say anything about the Exhibit 4, my lord.
No, that's what I'm asking. What is Exhibit 4? Who proved it?
It was proved by
Because I wrote in my note, PW4 had proved the medical legal report.
yes, my lord. Register Department of Surgery, my lord. Page 613, my lord.
613?
Register Department of Surgery, my lord.
He's PW?
He was not examined. No? I have to check up, my lord.
Okay. No, because why did I write PW4 approved medical legal report? So where did I write it?
What's the name?
Lordship will find PW6, he refers to 4. Exhibit 4.
PW6 referred. Okay.
Yes, ma'am.
So it should not be. It should not be 4. It should be PW6. 6 has proved PW.
6 is the medical officer.
Who proved Exhibit 4? Okay.
Register to him.
He is doctor. His name has not come.
Dr. Kumudlal Bora.
Kumud Ram Bora. Kumud Lal Bora.
Yes, ma'am.
Because in the judgment, this name is not there. So that's why I've missed it. Okay.
Cross-examination for accused Ajay Basumotari. I have come to the court first time. I have come to the court with my elder brother. I sat in the last bench in the courtroom where other persons were also sitting, my lord. That is important, my lord. My humble submission before your lordship is that in last bench, normally accused person is sitting, my lord. Even it is assuming not meeting, other person is also there. They have to be examined by the, my lord, learned trial court, my lord. When inquiry was made, but it was not done, my lord. I was interrogated Tezpur police station. My statement.
That is PW? You're
I
doing
am
PW?
PW4, my lord. Because PW4 is the, my lord, as per my lord, prosecution case identified. Me. Case 615. I was interrogated in Tezpur police station. My statement was recorded by police. Next important, I did not give any facial description of the assailant before the police. Very much important, my lord. There are some witnesses said that this person were entered into the, my lord, village wearing, my lord, masks in their face, my lord. That is available, my lord, in evidence, my lord. He has not given facial description. It is not a fact while assailant were firing at my mother and brother, I did not see at their face. It is not, I have been falsely identified person in one of the assailant, my lord. My humble submission before your lordship is that if your lordship go to the PW 40, because he is another eyewitness, is 107, my lord. And my lord, he has the PW4 not mentioned the name of my lord, Konam Hemram, and my lord, his mother, he said, Belamoni Hemram, my lord. Page 107, my lord, PW40. Sonamoni, sorry, my lord, Sonamoni Hemram, my lord, not Belamoni. Sonamoni Hemram. No. Other mother's name Sonamoni Hemram. Of PW4 mother's name is Sonamoni Hemram.
Yes.
Yes, my lord. PW 40107, my lord. Who is another eyewitness, my lord, of killing Korno Hemram and Sonamoni Hemram, my lord. So no, only my sorry, Korno Hemram, not Sonamoni. His name is, my lord, Bimola Kurmi, my lord. See, her name is Bimola Kurmi, my lord. I am reading page 107 slowly. Today,
Yes.
I appeared on receipt of the summons from the court on 23/12/2014 at around 4:30 to 5 p.m. Myself, sister-in-law, father Mohabir Kurmi, and my children were sitting in our courtyard, my lord. One is important time, my lord, 4:30 to 5 p.m. 23/12/2014 at night, my lord. In my lord, in December month, my lord, 23/12/2014.
5 o'clock is not night.
What, my lord? It's called, my lord. Dark is coming, my lord. 4:30 to 5, my lord. In my lord, December month.
Yesterday, Mr. Chaudhary, I put a question to one of the other council. You see, I have very limited experience in staying in village,
Yes, my lord.
but I believe that you have had experience in staying in village for a long time.
I have not,
No.
my lord. My father, my lord, born in Julpukuri, Papel.
No, that's okay. But The lawyer had some experience in staying in a village. I was pondering on a question. You see, in my limited experience, I have never seen a night where it is pitch dark and you can't see anything. I'm yet to see a night where it is pitch dark and you can't see anything.
Yes.
Because in my own home, I have not been in a site of crime, but in my own home, even if I'm not fully, when I'm not fully asleep, from the footstep I can make out who's walking. Inside my home, in the family members, I can just make it out, even if I'm not looking at the person or the face. With the footstep, I can make out if somebody is walking is my family member. That much I can understand. Family members with their with a shadow of theirs, I can point out who's who. But pitch dark, I'm yet to see. I don't know about your experience, but personal experience is that. You've seen a pitch dark.
Lordship, is that experience, Lordship, when you're in the cinema hall and suddenly the line goes up, then for a few seconds it's pitch dark. Otherwise,
No, that is because of the, you see, that is that's for a light blindness.
Oh.
You are in a glare and then suddenly you don't see anything.
But after
That
5,
would
6
also
seconds,
happen when again you see in a pitch dark, you see a bright light. Then also you can't see anything.
Yes, that's one, yes.
It's a
the
blindness
same
caused by, it's not a pitch dark otherwise. After 2 minutes, you will still know what is happening where,
Yes, yes.
even inside a cinema hall.
It becomes accustomed.
But next line. Suddenly we saw some NDFB cadre kill Korno Hemram by firing bullet from firearm in front of his house, which is situated just opposite of our house. Contradictory statement made by PW4. He said the assailant entered into their house, my lord, and thereafter, my lord, fired to his brother, Korno Hemram, my lord, and he died on the spot, my lord. And here, my lord, he said it was happened in front of his house, my lord, which is situated just opposite to our house, my lord. Both statements are contradictory in nature, my lord. Next line, my lord. Seeing the incident, my brother asked us to run away. I could not run away because of my ill health entered into my dwelling house. My father and sister-in-law ran away, and my 3-year-old minor daughter was with my father. The NDP captor says my father Mohabir Kurmi and shot dead in the paddy field in front of house. My minor daughter escaped and her started crying. I came out to her. The mobile handset of my father was taken away, said Kader. On earlier occasion, NDP cadre are visited on the day we did not know they would kill us. Next cross. I did not lodge an Azahar before the PS of the aforesaid incident. Nia has recorded my statement. It is not a fact that I have not stated before the Nia that I could not run away because of my ill health, entered into my dwelling house. It is not a fact. I have not seen before the Nia that NDFB cadre says my father Mohabir Kurmi shot him then in the paddy field in front of our house. It is not a fact. I have not stated before Nia that on earlier occasion NDFB cadre would arm our village on the day incident. We do not know they would kill us. It is a fact that I have not stated Nia and NDFB cadre were involved in the incident. My humble submission before your lordship is that, my lord, if he saw the person who killed the, my lord, Korno Hemram, then he should identify the accused person. Same way of PW4, that was not done in the instant case. He did not take my name, my lord, in my lord, examination in chief, my lord.
Just
sorry. Gender মানে একটা actress তো না actor.
Just, it is not relevant, but
Yes.
not very relevant. And the last is the photograph of the moon position from Assam.
Yes.
It's a third day crescent.
This one.
Illumination is 7.24%.
This one.
But from the sky, this is the position. So it's not absolutely pitchless dark.
Yes, ma'am. Correct, ma'am. Your also is absolutely correct, ma'am.
No, nothing to do with this matter, but just.
Well, this
Can
matter
you-
also it come, Milo, because he saw the person and they are not identified the person.
But that point you have
Yes,
made a
my
good
lord.
point.
Because he is the best witnesses. She is the best witnesses in this case. And if your lordship read PW4 Milo, I come my 7.9, 8 point Milo. First point is that I prepare Milo 8 point Milo.
Just let me compare it again.
PW4. PW4 to 8 point আছে। ও আস্তে আস্তে করবে। আস্তে আস্তে করবে। মোৰ এই পিচটো ডাঙৰ এখানে সৰুকে কথা দিলে এইটো কোৱা নাই।
Yes.
Yes, my lord. You'll also kindly note down my
Just a moment. Yes.
first PW4 my lord. I have already stated first time statement made before the court mentioning my name, my lord. 1 point. Second point number, Ojoy Bosumotari. I was arrested on 22/2015. I was on arrest in this case, my lord. Earlier, I was arrested in connection with Vishwanath. Earlier, I was arrested in some other cases, my lord. It would come the evidence, my lord. Search sheet file on 22/7/2015. After 5 months was in custody in connection with this case, my lord. But no TIP was conducted, my lord. by the prosecution, my lord. Secondly, my lord, 161 statement.
Was that point urged before the trial court?
My lord, I am very sorry to submit before your lordship is that I will go that judgment, my lord. Cross-examination part was not taken, my lord, properly. If the, my lord, cross-examination part was not taken properly by the, my lord, learned counsel, whether that can be hesitated in case, particularly in death sentence has been given to the accused persons, my lord. This is a case of, my lord, where death sentence has been, my lord, conducted. I will give all this, my lord, later on, my lord. Next, my lord, 161 CRPC, it is stated that read over in Hindi found correct, but in court statement that was not done, my lord. If your lordship 161 CRPC statement of the Kati Hemram, my lord, because 161 statement can be looked, my lord, for acquitting the accused person, my lord. Last line, read over in Hindi found all correct. But if your lordship go to the evidence taken before the court, my lord, there it was not written, my lord, these things, my lord. There is some order I have found, my lord, when the evidence has been recorded, that so and so does not know, not conversion with the English language. So it was read over and explained to him. Here it was right down, RO and SC, read over and accepted, but that line is not available. Because, my lord, I am arguing on this point because it is a death sentence has been given, my lord. Your lordship, kindly look, when there is a, my lord, more stringent punishment has been given, more degree required to be proved that case. I have a judgment, my lord, to that effect, my lord. Secondly, my lord, no facial description of the accused has been given in 161 CRPC statement. He has admitted in cross-examination, PW4, that he has not given any facial description of the accused person.
Is that a requirement of law?
My humble submission before your lordship is there because if he identified a person directly before the court, my lord, then they have to look all these things, my lord. That this is the, if he said in 161 statement that this person is like that, and if it's similar to the, when he identified before the court, because he has not know the name of the, my lord, accused person. In court, my lord said that this is the person, he said. So earlier he give this thing, my lord, before the court, my lord, before the police, that facial discrimination has been given. Then I have to, my lord, because there is a serious allegation that Mia people has identified the accused, tutored the accused before the court, my lord. That is why I am submitting all these things, my lord. And another important thing is that, my lord, although I do not know, my lord, whether it is the acceptable argument or not, my lord, there are several people are there, my lord. And people, that accused person on that particular date, my lord, he is wearing some cloth and other, my lord, his head. Whether the, when he is, my lord, identified by the, my lord, before the court, my lord, whether that has been said, that was not done. I am not found, my lord. This type of way. Then I have tried for their test. What judgment I get, my lord, for their test, all are below 10 years, my lord. I am submitting, my lord. I will further, my lord, study on this point, my lord. My elder brother, my mother name not mentioned. Sorry, my lord. His elder brother and mother name was not mentioned in his evidence, my lord. Who is elder brother? Who is mother? That was not mentioned by the witnesses, my lord. That my elder brother is the Kati Hemram and my mother is the Sonamuni Hemram. Because if your lordships go to the site map, my lord, nobody has been recovered inside the house. Subject to correction, my land of film, my lord. And last point, my lord, Kati PW4 identified after 18 months. I have already argued, my lord. After my identified. Exhibit 125, no? And helpful one corner. Goodness, one corner. Okay, no. My lord, your lordship kindly look to the exhibit 125, my lord, page 961, sketch map of the
You see,
body.
some memories triggered. I just shared with my brother. It's a wonderful memory which you have revived. At that time, I was a lawyer. I was in Calcutta with a client, and we were having a food in a restaurant. And while eating, the person says that this food I have had earlier. I think I have had a similar food, similar taste in Bombay. And then he asked the floor manager, about 2 years back at Bombay and so hotel, the chef here who has prepared this item, was he the chef there also? The floor manager went, and after some time the chef comes and said that yes, I am that man. But how did you remember the taste? So you see, there are persons who are connoisseurs, and this year, in the beginning of this year, he expired. But the memory which I retain of that incident, you see, having food in a restaurant and recalling that he has eaten, somebody has the same quality of food in a different restaurant about 2 years ago. That's marvelous to me.
But, then, Lordship, I am surprised Lordship has keeping track of that person. He's expired 2 years back. Lordship has keeping track of that person. Lordship now says he's expired 2 years back.
No, about this, in the beginning of this year.
I'm sorry, beginning of this year. But
No,
why
these are few people who have become family friends. There are only 4 or 5 of those people are that in that life who have become family friends. He is one of them. I still visit their house.
Lordships, that client, I was thinking about the cook.
Exhibit, my lord, 125, my lord, page 964. Paper book number, my lord, 4, volume 4.
Page number?
Page number 964. Oh,
Place of occurrence.
yes, madam. Place of occurrence, my lord, last graph cast map, my lord. Lordship, kindly look to the E. Left side, my lord. Second left, my lord.
E, yes.
Courtyard where from the dead body of Colonel Hemram was lying. It was in the courtyard. Here's the sketch map not supported the statement of PW4. Rather, he supported the statement of PW40, my lord. Next, page B, my lord. Right side, my lord. Upper right side, my lord. Paddy field where the dead body of Sonamoni Hemram lying, my lord. That statement was supported, my lord, of my lord. 40 statement has been supported this case, my lord, not my PW4, my lord. And if you also come to next page, my lord. 965. B, indicate the paddy field where the dead body of Sonamoni Hemram was lying. Then you'll also come E, indicate the courtyard where the dead body of Korma Hemram was lying. So PW4 statement was not supported by sketch map, my lord. If that is so, if PW40 statement has been supported, my name is not mentioned by the PW40. I want to show another swing menu from the sketch map.
Anybody in this courtroom is from Pathshala? No.
No,
You are from Pathshala?
not exactly 2 kilometers.
2 kilometers, then you would know. In Pathshala, I won't name the person. Either he's alive or the last year he died. I don't remember exactly. In Pathshala, there was a gentleman whom Alpha shot 6 times on the chest. With that condition, he came to Guwahati, went to the medical college, where he was told to have a hazard lodged. And he went to the police station, lodged an hazard, and again walked out in the medical college, and there he collapsed. And then 6 bullets were pumped out from his chest, and he lived. Now you'll understand the name I'm referring to.
In fact, Lordship, while I was attached with my senior, I was interested in this ballistics and all. So there was a book, I took it out. And in one chapter, I could find a person, he shot himself like this, and the bullet did not penetrate him. Like from here, bullet did not penetrate him. Then there was an example of another person who suffered a bullet injury during the war, but they could not locate the bullet in his body, and he was pulling around very fine. And after many years, he suffered from cough, and then the bullet came out. It happens, Lord.
Your Lordship, kindly look to the my lord, sketch map, my lord. If your Lordship look to the sketch map, my lord, then the house of my lord, Kati Hemram, my lord, the courtyard in my lord E has been mentioned, my lord, and body of his mother was found, my lord, B. Your Lordship, kindly look in between, my lord. There are many houses, my lord. 1, 2, 3, 4 houses, my lord. Have your Lordship got it? And he sustained bullet injury, my lord, PW4. And his mother was died here, Annex B, my lord.
Paddy field B.
Paddy field B, my lord.
Huh.
This is the, my lord, long distance, my lord. There are pond is there, thereafter another person house is there, my lord. Yes, my lord. So my humble submission before your Lordship is that, my lord, if he has got bullet injury, my lord, how can he see that his mother was killed in place B, my lord? If you will also go to the evidence, my lord, he said PW4. I again read, my lord, that part, my lord. Subsequent, right, when my mother tried to flee, he also dead my mother. Tried to flee. Yes, my lord. He also shot dead my mother, my lord. Sorry, my lord. Have you also got it, my lord? Meaning thereby he killed his mother there, my lord, as per his statement. But body was found here. And if your lordship go to the PW40 statement, my lord, he said his father was killed, my lord. Mahabir case number. Mahabir Kurmi, my lord. It was found in F, my lord. Just near the house of the, my lord, Korno Hemram, my lord. So it proved that the person who killed the Korno Hemram, my lord, may also kill, my lord, Mahabir Hemram, my lord. But it is not possible, my lord. Person who killed, my lord, Korno Hemram here, my lord, inside the house, he said, my lord, a body was found there, my lord. 85. There are many houses, pawn is there, my lord. And he has not said, my father, after, my lord, she was shot by the assailant, my lord. She ran away from the there, my lord. And after that, he is it. But his statement I have read, my lord.
Okay.
If the Sketchman supported the statement of PW40, where my name was not mentioned, I was not identified. I have already read, my lord, evidence of PW11, my lord. PW12, my lord, is related to me, my lord. Page 39, man. Today, I appeared before the court on received summon. Sorry.
You're reading whose statement?
PW12. Earlier, I read up to PW11, man. PW12. It is my related to me, man. Page 39. 39, my lord. Page 39, my lord.
Yes, yes.
PW 12.
Birdaula.
Yes, my lord. His name is my
Basmotari.
lord, Miss Bidola Bosumotari. Today I appeared before the court on receipt of the summons from the court. I am working as village headman, Gaunpura of village Dulia Gaon. For the last 3-4 years, permanent residents of the said village since long. That is important, my lord. I am no one Ajoy Bosumotari who was a resident of our village. His father's name is Bolendra Bosumotari. According to my knowledge, he is also known as Babu, but I do not know if he has any other name. About 7-8 years back, he left his home, telling his family member that he would go to Kerala in search of job. Actually, I do not remember the time, but May about 1 year back, police inquired from me, village headman, about Ajoy Bosumotari. When I inquired with the police as to why they were searching Ajoy Bosumotari, police told me that he had joined NDFB. The knowledge gathered from the police that cannot be taken as an evidence. After 2 months, I came know from the police that Ajoy Bosumotari was arrested by Bokazan police. Subsequently, I was arrested in this case, my lord. I know Ajoy Bosumotari very well. I am in position to identify him. The witnesses either Ajoy Bosumotari, many other accused. Ajoy and myself belong to the same village. To my information, left his home to go to Kerala for doing some job about 7-8 years back. Next line important. I have identified today Ajoy Bosumotari in the court because I am as a co-villager, not as a member of NDFB. So no witnesses, my lord, stated that he is the NDFB member, except one PW 61 said I will come later on, my lord. And my lord, I am submitting here, my lord, one point is important, my lord. The prosecution has not taken sanction for section 16, member of the unlawful organization in this case, my lord. I will come later on, my lord, that point. I came to know from police that Ajoy joined NDFB. All information gathered from police. Before leaving for Kerala, he was known me as a good person, having keen interest in sport and military activity. He probably matriculation examination. I had no as to why Ajoy Bosumotari was arrested. PW 13 is not related to me, my lord. May I read or my lord? May I skip?
You will skip if it is not
Yes,
relevant to
my
you.
lord. Yes, my lord. It is not related to me. PW 14, my lord. Hmm? The 16K. Number 2 months. Number 15 to member, no? 15 to member. So, we will talk about these two. Actually, my lord, I am wrongly submitting before the court. 16, my lord, punishment for the terrorist act as per UAP Act, my lord. 20 is the amendment. 16, no permission has been taken by the authority, my lord, to investigate the case, my lord. And I redeem, my lord, now page 43, PW 14. His name is, my lord, N.S. Beast, sorry, N.S. Beast. He is the Undersecretary Government of Ministry of Home Affairs. Today, I appeared before the court on receipt of the summons from the court. I had been working Undersecretary Government of India, Ministry of Home Affairs, New Delhi since 2012. I issued the order dated 27/12/2014 on behalf of Government of India for transferring the 4 cases, including the case number 738/2014, registered at Thekiajuli PS to NIA in accordance with Section 64 of NIA Act, seeking approval of Union Home Secretary. Exhibit 26 is the said order. I received the investigation report along with all enclosure, including the statement of witnesses, on 13/7/2015. I referred to the aforesaid report. Will all enclosure authority constituted under Section 45(2) of the UAP Act, comprising Justice so-and-so, and Sri so-and-so, former Law Secretary, Government of India, for independent review of the investigation. One page is missing from the paper book, my lord. I do photostat by that page of the evidence. Whether it is available your lordship paper book or not, I do not know, because it is in page continuously 43 after 43, 44, my lord. But there is one page.
Okay, we don't have it here.
Yes, my lord. I have a, my lord, extra copy. Huh? At page there, my 44 আছে, at page 30 is cross examination.
Is it in 3 pages, out of which 2 pages are in the paper? Middle page is missing. It's not a 2-page statement, it's a 3-page statement.
My lord, next report and making appropriate recommendation. The authority submitted recommendation to the Ministry of Sanction for the prosecution against 4 accused persons: Sonju Bordole, Eli Shivgiri, 120B, 121, 121A, 123 of the IPC and Section 1820 of UAP Act. Vishnu Narzari and Burma, 120B, 121, 121A, and 123, and Section 16, 1820 UAP Act. Ajoy Bosumotari Mela, important. Eli Bahum, B. Bahum, under Section 120B, 121, 121A, and 123 IPC, and Section 18 and 20 of UAP Act, my lord. 16 is not available, my lord. And Nitul Doimari, D. Noya, 120B, 121A, 123, and Section 18 and 20 of UAP Act was issued after perusal all document and application of the mine with the approval of Union Home Secretary on 27/2015 in connection with case number RC04/2014 near /GUW, which was registered by NIA Guwahati branch. Exhibit 27 is the sanction order in 3 pages and Exhibit 27(1) signature. I prepared the sanction order Exhibit 27 and signed on behalf of President of India. There was a small typographical error in the aforesaid Exhibit 20 in the last sentence paragraph, when date of the incident was wrongly typed as 23/12/2004 instead of 23/12/2014. In order that mistake has been happened. The FIR dated 7/38/2014 on Thekiajuli PS was registered 24/12/2014, which has been indicated correctly. In the Unlawful Activities Prevention Recommendation Sanction Prosecution Rules 2008, there is a mention of authority. it is mentioned exhibit 27 as on which date the aforesaid authority was constituted by the central government. That is not available. When it was constituted, that is also not available. I have also mentioned the notification number by which the authority was constituted by the central government. In exhibit 26, I have not mentioned the date on which investigation report along with the enclosure were received by the authority constituted by the government of India. It is important, my lord, time period is there, no? 7 days, they have to, my lord, give their sanction, my lord, after receiving all these things. I'll come later on, my lord. It is not, I received back the recommend authority. There is also no document right now available in the case record to show as to on which that authority received the investigation report sent back to a recommendation. However, I volunteer to clarify that on 13 July 2015 and the report authority was 16 July 2015 and undersigned sanction prosecution 25 July, which is within the prescribed time in the aforesaid rule. Because my date is not available, only his ocular statement whether that can be considered. It is true that the aforesaid date are not mentioned in the document which I exhibited today, but I am telling from my memory. He has said from the memory, my lord, but document that is not available, my lord. Whether, my lord, it is permissible under the law, my lord. In exhibit 27 is the sanction order. Detail of the material collected against the accused have not mentioned. There will be found statement of witness document filed by IO. I deny the suggestion the authority did not communicate their recommendation within the prescribed period of 7 working days from the receipt of investigation report. I deny suggestion that sanction order was not following the laid down rule and procedure. I deny the suggestion central government did not issue any sanction order within 7 days after receipt of the recommendation of the authority. It is not the fact that there is no document to show the central government did not accord sanction to the accused person under section 196 CRPC because it is necessary for 121A. 121A for that is necessary. I will clarify later on this point. The sanction authority. The witness volunteered to see, it is correct that I am not the sanction authority. He is not the sanctioning authority. That is important. And sanctioning authority was not examined in this case. The witness volunteered to say that I am authorized to issue sanction order in accordance with the authentication order instrument rule 2002.
Next one.
Worship, you'll find that at page 683 and 684. Sanction. Page 683 and 684. Continuous 686. Volume 3. Volume 3.
UAP National Investigation Agency Act, the Act, National Investigation Agency.
Lordship kindly look to the unlawful activities prevention book, my lord. The unlawful activities prevention, recommendation and sanction prosecution of the rule. Page 38, my lord. It was 2015 book. If your lordship come to the point number 3, my lord, have you lordship go to page 38? Then time limit recommendation by the
7 days that we have seen.
Yes, ma'am.
National Investigation Agency.
Yeah, yes. You can have my book.
It's okay. Yeah. So the second point is raised. This sanction, the requirement will follow this provision of section 45 of the UAP Act. 45 says cognizance of an offense. No court shall take cognizance of any offense. 2 is under chapters 4 and 6. Now 15 and 16, Terrorist Act and punishment for terrorist activity is under chapter 4. So definitely this document you are showing 683 has no sanction under chapter 4. Therefore, we did not go into the evidence at all. The question of cognizance is not there. The question of conviction and punishment will also not be there.
No, no, Lordship, this is for investigation. Now, Lordship will come to the next document. 684. 684.
684.
684. Here, 684, you can keep it. 686.
So again, the 16 is not there.
16, Lordship, I do not find in respect of A3, Lordship.
So it's not there.
69.
He is not in charge for section 18 and 20.
Lordship, 69 and not find.
Huh?
69 and not find, Lordship.
So 18, 20 is not there. The question of goes to the root of the matter. We do not go through the evidence at all. Because if you read 45, it says no court shall take cognizance.
Yes, Lordship.
So it's not a question of investigation, it's a question of cognizance by the court. If cognizance can't be taken, question of evidence and then conviction and punishment, all will go.
That I'll have to apply my mind. I'll have to find out something if it's there. But on the face of it, Lordship, this it does not.
It's not there. So put to this question, and doing this unnecessary exercise would be nothing.
Lordship.
We give you time on this question and we'll post it on the
I will
next week.
advise your Lordship on the next week, Lordship.
We do not go into
Yes.
the evidence at all. Then
Yes, ma'am. Correct, ma'am.
if the sanction is not there, why
ma'am.
should we spend our time?
Yes, ma'am. Yes, I have to advise your Lordship. It depends on the- Admittedly, it's not there.
In these two
Okay, yes,
documents,
ma'am.
you may have anything else.
Yes.
Mr. Nandi Chaudhary,
Yes, ma'am.
I think the beginning, opening words of mine, I have to take it back.
Yes, ma'am. Actually, in this case, I was the tail ender, my lord. Subsequently, my senior was died. I am arguing counsel in this. This benefited lordship. No, I never say. No. I learned anything from my senior. It's not that.
He's not saying in negative sense.
Yes, sir. In fact, lordship, I just for his lordship, in fact, I remember lordship 2005 something, a case was there before Justice I.N. Sir, that court behind. And my senior was there and his senior was there on the other side. And something happened and my senior asked me that you appear in the case. And since his senior lordship, I was no match for him. And that was my first opportunity to argue before a senior advocate of his stature. And I took it as a challenge. The case went on for 3 days. I did not let go. And ultimately, Mr. Datta came out and told me that you did well. So that is what.
In course of submissions, Mr. N.N.D. Chaudhary, the counsel for the appellant, Ajay Chaudhary, sorry, Ajay Basumatari, in criminal appeal 342 of 2016, oh, sorry, 18,
35818 Mala.
3
58 2018 Mala. Criminal appeal number. Your Lordship, in paper book, first page. Ajay Basumatari, bottom Mala, 358, just before, just above.
358, 358, in 358 of 2018 has referred to the order of sanction dated 27/12/2014 within bracket exhibit 26 as well as order of sanction dated 27/2015 within bracket exhibit 27 to project that amongst others, the appellant has been convicted for commission of offense under punishable under section 16 of the unlawful activities within bracket prevention bracket close act 1967. However, in the set to sanction orders, the competent authority had not given sanction to prosecute the appellant for committing offense under committing offense which is punishable under section 16 of the said 1967 Act. Accordingly, command is submitted that if no sanction was available, for punishing for punishing the appellant under section 16 of the said act, there will be no requirement to go through the evidence as the trial court would not have the competence to take cognizance of offense committed under section 16 of the UAPA Act. UAP within bracket, and punish the appellant under section 16 of the said act. Next paragraph. In view of the issue raised, Mr. R.K. Chaudhary, Leonard, DSGI, who is present, shall address the court on the said preliminary point raised by the learned counsel for the appellant. The praise for him is granted time to address the court based on when. That's the date because now the bench is will be on for this matter.
Let it be, Lordship, after Ninth, Lordship. 9th of October.
We supposed to have it the first week of October. The second week is a bit inconvenient. The we may not be this same bench may not be available. And
Lordship, on that day, Lordship, I'll address your Lordship on this point, raised.
only at this point.
Only on this.
Well, yeah, otherwise doesn't matter. It only alters the situation.
Yes.
If UAP is not there,
Yes.
then we need not see it through the voluminous evidence. Then we have to concentrate only on these the witnesses who have seen the occurrence, based on which 302
Yes.
he has been sentenced with death sentence. So the entire voluminous evidence is not required to be gone into for this appellant, at least.
Lordship, perhaps Mr. Agarwal will not be required on that day. The amicus, perhaps he will not be required on that. No, on that day. On the next day.
On the next day is okay, because this is for you
Yes,
to
yes,
address. His requirement is only on the when this is being taken up. When death reference is being taken up, that we have already postponed. Take it up on 4th or 5th, whenever you
Yes,
want.
yes. Yes, Lordship.
Fourth, my lord.
Fourth.
Fifth
Fifth.
Fifth is a hearing that,
Okay.
If I have, after doing that,
all right, fourth lordship. Sorry, please come fourth lordship.
This one that small
Yes,
issue.
yes.
This one 4/10/2023 as a pattern matter. For others, we can proceed post lunch.
this one,
So far as
my,
no, we are asking you. We have already said about the altered position.
this one.
So that death reference and the 302 still remains.
That's fine.
So you want to continue or you want to
On that day, I will argue, my lord.
on that day? So today
Yes,
we
ma'am.
defer your argument also.
Yes, my lord.
Actually, just before that, you right, the submissions of Mr. Anil Chaudhary, counsel for the appellate remains inconclusive. After that, in course of hearing, yes, please.
Item number 4. Yes, 4, I got the medical report, Lordship, from Dibrugarh jail. She said to be okay. I mean, that report can, Lordship can see. This, oh yes, that is there before your Lordship. It is said that although she was quite of an age, she is 78 years, but then it said that she is, the word that was used by the doctor, yes, she is clinically stable and afebrile. The afebrile I've
If
seen.
she's 78 years of age,
Yes.
you can enlarge her
Lordship,
pending
yes, yes. So it's too old for.
to being assassinated.
Hmm.
So that's the only reason.
Because there are
Just-
2 appellants, and she's appellant number 2.
Just
I don't need coffee.
what is the evidence? What is the participation in the crime?
Yes, I have my objection that her dying declaration is there, and she said it was the applicant who had poured the kerosene and appellant number 2 had lit it. That it's there.
Okay.
Yes, this is Lordship will find. Torture and all 498A and plus 302 is there.
That for the time being will not consider for the purpose of bill, but her participation in crime for 302.
302. This is the dying declaration. Lordship, this is circle officer has recorded the dying declaration. He is examined as PW5. PW5 statement can be seen.
Just
Lordship.
Richard is not come.
Answer is here. Applicant number 1 tied her, and applicant number 2 had poured kerosene and set her on fire. This is what the dying declaration. And that earlier, her mother-in-law used to beat her and scold her.
Statement of circle officer.
Yes,
He
PW5.
is
PW5.
Then, Mr. Mishra, we will not be unkind if that is the case. We'll rather list it for expeditious hearing. Because the principle, my brother is right, is that there must be with age, and then we can consider. Heard Mr. Arish Michelle and counsel for the applicant, as well as Mr. S. Jahan and the APP for the state. Next para. By filing this application under section 389 within bracket 1 CRPC, comma, the applicants have paid for suspension of sentence passed by the order dated 6/12/2022 in connection with order of conviction dated 5/12/2022 by the learned Sessions Judge Dibrugarh in Sessions case number 164 of 2013. By the said order, the appellants were convicted of committing offense under section 302 IPC and sentenced to undergo life rigorous imprisonment for life. And the appellants were also convicted for committing offense under section 498 capital A IPC and ordered to undergo imprisonment for 2 years. So in addition, the appellants were directed to pay fine for both the offense and with default stipulation. No, not with that, containing default stipulation. Next paragraph. The learned counsel for the applicants has submitted that there are good grounds for the connected appeal. And that there is every likelihood of the applicants being acquitted. Moreover, comma, it is submitted that insofar as applicant number 1 is concerned, comma, he is the sole breadwinner in the family and has a minor son and other family members to look after. It is submitted that the applicant number 2, who is the mother of applicant number 1, is a lady aged about 78 years. And therefore, considering the age of the applicant number 2, prayer is made for suspending the sentence pending the disposal of the connected appeal. You want anything more to be added? Next, the Ms. S. Jahan and the APP has referred to the objection filed by the state in the matter and has referred to the evidence of the circle officer, come executive magistrate, was examined as PW5, and it is submitted that the said witness had recorded the dying declaration of the victim who had implicated the applicants for the offense. Full stop. Next paragraph. At this stage, the court is not inclined to appreciate the evidence for the purpose of evaluating the evidence. full stop. Nonetheless, comma, the court finds that the applicants had been convicted on materials available on the basis of materials available in the evidence, which implicates the applicants of participating in the offense of committing homicidal death of the victim, who is the wife of the applicant number 1. And there are, and as per the Learned Trial Court, there are materials to show that the victim was tortured for dowry. Physically and mentally tortured for dowry. No? Physically and mentally tortured for dowry. Next one. In light of the discussions above, notwithstanding that the applicant number 2 is a lady aged 78 years, the court is disinclined to suspend the sentence of and or grant bail to the applicants pending the disposal of the connected appeal. So according to the prayer for bail is refused, this application stands disposed of. Full stop. Separate orders being passed to the connected appeal for expeditious preparation of paper book and for out of turn hearing, considering the age of the applicant number 2. In this appeal, you write, as the trial court records have been received, the registry shall prepare the paper book as expeditious as possible. Not continue, because considering the age of the applicant of the appellant number 2, the court proposes to pass an order in due course for out of turn hearing. The age of the appellant number 2 which is stated to be 78 years. Next paragraph. But we'll fix it after 6 weeks. The registry is doing some urgent Supreme Court directed work for translation. After 6 weeks, give a date. Based on so awaiting preparation of paper book.
It will go to December then. No.
Whatever
November. November. 15 November. That medical condition thing is not required to be written perhaps in the order.
Oh, no, it should be done. Once it is there.
Because there is an order.
No, we forgot. Just before the rejection in the IA, they just had the Learned APP has also produced a copy of the medical examination report of the applicant number 2. Received from the Superintendent of Central Jail Dibrugarh, which contains a communication from the medical and health officer 1, jail hospital of Central Jail Dibrugarh to inform that the applicant number 2 at the time of examination was found clinically stable and efebrile, AFEBRILE.
This is not feverish. I think I've checked it in the dictionary. Not feverish.
Not
Efebrile.
feverish. Okay.
I have never heard of this word before.
No, I have not. Her BP was 130/80 mm. of 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 capital H small g, then semicolon, PR dash 78 oblique minute MIN, SPO2 dash 99% on capital RA, semicolon, temperature dash within bracket capital N bracket closed dash febrile FEBRILE and all other of her vital signs SIGN signs are within the normal limit and doing well right now. So the said communication is dated 22/9/2023. This we had with the submissions of GP.
Medical report is before you. I've given it to them as well. This would is.
Earlier, the emergency which was there is no longer there. Mr. Borgohain?
Yes.
The earlier emergency which we are showing is no longer there. So that earlier problem has gone.
Or as your lordship has given in para 5. Whether they have made any examination to that effect is not reflected.
Page 3, Assam Medical College they have taken.
It's reflected in the first letter.
Now he has low backache.
Okay.
Yes, and loss of appetite.
Weight loss.
Weight loss is there. Loss of appetite and history of, no history of melena and dysphagos.
So I think we'll ask the jail authorities to continue monitor, continuously monitor within periodically.
Not. Yes.
Just wait, just consult.
এইটো হেৰি নাছিল জানো হাতখন যে কাটি গৈছে এইটো হাতখন কাটা যে মানুহটো নহয় নি এইটো বেলেগ কেছ এইটো হেৰি এক্সপ্ল'চিভ চাবজেক্ট নহয় Explosive substance এক নহয় নেকি এইটো?
কিবা যে সাৰ বনোৱাৰ এজন নদী পাইপ কৰে যে কৈছিলে।
Oh, আচ্ছা আচ্ছা। নহয় conviction explosive substance নহয় নেকি এইটো? নহয় এইটো ভুল কৈছো। এটা আছে convict আৰু medical report আহিছে। হাত কাটি আছে, তাৰ কাটা আছে।
Subject to how you address us, we are proposing that we will issue a direction to the jail authorities to have his health condition monitored every 2 weeks. And if required, there we'll also say that their family members, if they visit, they will provide with copies so that you can have it.
Yes.
Medical prescription can be handed over to copy to them.
Yes, of course. They'll know then. And paper book is ready. Now, now
Fix it
that
for hearing.
yes, fix it for out of
Yes.
turn now that he's not very well.
Only fair, my lord, if your lordship can consider for a early hearing of the whole matter.
We'll do it.
Yes.
We'll do it. Consider that.
I is pending otherwise. I is pending.
This I is for that purpose.
For wait. I may be kept pending, matter may be heard together. Oh, don't know.
Your lordship may dispose the eye.
Earlier one was disposed of.
Yeah.
No, here also, because the disposal is better, because here we'll get a ground to for expeditious hearing.
Yes.
Otherwise, again,
Again.
the problem is there. So I
Yes.
is otherwise.
No, that should.
Okay.
Yes.
Because we have a lot of faith on the submissions of Mr. Borgohain, as he has multifaceted experience in this court since the day we joined. He was the government counsel, senior government advocate, additional advocate general. We have seen him in this side more.
He was Advocate General also, I think.
Yes, advocate general was there, but that was at a later point of time when that. But incidentally, when I'm saying when I joined.
Yes, yes.
I had the opportunity to address your lordship so many times.
Huh?
I had the opportunity to address your lordship so many times as government advocate or additional advocate general.
So that's why we respect his.
Yes. It was on both sides.
Mr. AC, and earlier, the judges of earlier point of time, before I joined, had a different name for Mr. Borgohain.
Achha, oh, I didn't know that. I still don't know it. I'll ask him and I'll let know.
He had been given a British name.
Oh, achha. Oh, yes, yes, that we know. I don't, yes, no. Oh, I'm saying no.
And you see, that with respect,
Oh.
not with disrespect.
Yes.
With the respect, nobody.
That was a
nobody-
Governor General of British's,
No, whatever way, I'm not saying it right
not
now.
Einstein.
If you know it, you can, you can, what you call, you can take a Hezbollah with it. But but what I'm trying to say is that even the judges of earlier times,
Mm.
they used to address him with respect.
Yes, yes, of course. Even the nickname had a respect in his own regime, during his own regime.
So that's why, when I say that we respect his,
Hmm.
something, not,
We actually
just
forgot,
born out
Lordship
of
reminded
anything.
us. We knew, but then we
not,
forgot.
not out of thin air, but I have reasons to make that statement. I'm sorry, I just recollected old times. I'm sorry, no intention to hurt you.
No, no, I know that.
Never.
Mr. A.C. Buragoy, Senior Counsel, and assisted by Mr. R. Singh, Counsel for the applicant, and Ms. S. Jahan for the state. Next para. By filing this application under section 389(1) CRPC, the applicant is a 75-year aged person has paid for suspension of sentence awarded by judgment an order of sentence dated 7/2/2023 passed by the learned additional sessions judge within bracket FTC Dibrugarh in sessions case number 158 of 2017. Thereby convicting the applicant for committing offence punishable under section 302 of the 448 IPC and sentencing him to life imprisonment along with fine and with default stipulation. First off, the learned senior counsel for the applicant had submitted that the applicant is suffering from various ailments, which includes dysphagia, DYSPHAGIA, degenerative lumbar spondylosis, SPONDYLOSIS, multiple disc, disc lesions, LESIONS, chronic kidney disease for last 6 months, and is and as per the medical opinion of an orthopedic surgeon on 25/1/2023, the applicant is suffering from degenerative spinal osteoporosis, OSTEOROSIS, and as per the opinion of the radiologist, the applicant is also suffering from chronic cystitis, CYSTITIS. Stop. Accordingly, first off, later on, during the period from 23/6/2023 to 26/6/2023, the applicant was treated in the Assam Medical College and Hospital, Dibrugarh, and as per the doctor's opinion dated 16/6/2023, the applicant was suffering from oesophagitis, OESOPHAGITIS, and pancreatitis, PANGSTRITIS. It is submitted that person to the person to take the court taking notice of the said medical condition of the petitioner or the applicant, by an order dated 23/8/2023 passed in the connected appeal and directed the medical examination of the applicant. First one. It is submitted that the learned APP has produced the medical documents of the applicant, which now diagnoses him of having low backache and has been advised various investigations, including ultrasonography, UGI endoscopy, ENDOSCOPY, and also for orthopedic consultation. So according on the ground of medical condition of the applicant, the learned senior counsel has paid for releasing the applicant on bail or to suspend his sentence. Next paragraph. The learned APP has opposed the player. Next paragraph. As per the current status of medical examination of the applicant, as per the opinion of the doctors of Assam Medical College and Hospital, Dibrugarh, who had examined the applicant on 29/2023, 20/29/2023, have opined that the applicant is suffering from low backache and there is a loss of appetite. No history of dysphagia, DYS, PHAGIA, melena, dysphagia, and melena. With other parameters appear to be normal. Nonetheless, is the considering the age of the applicant, which is stated to be 75 years, and his medical condition as appears from the prescription of the outpatient record of Assam Medical College and Hospital, Dibrugarh. Court is inclined to provide that the Superintendent of Central Jail, Dibrugarh, shall have the health condition of the applicant monitored every 2 weeks, and a copy of the medical status, medical report of the a report of the medical condition of the applicant be provided to his family members, so that to facilitate the same, the court is inclined to provide that any one family member of the applicant may provide his phone number to the Superintendent of Central Jail, Dibrugarh, containing WhatsApp facility, to which and of the email address by which the health status report of the applicant can be transmitted. Next paragraph. Considering that the applicant is suffering from low backache, with no other medical complications, considering the fact that the applicant has been awarded a rigorous punishment for life, the court is disinclined to release the applicant by suspending the sentence. Nonetheless, considering the age of the applicant, a separate order is being passed in the connected appeal for after 10 hearing. So the application stands disposed of. In the appeal, right? As the paperwork is ready, list the matter for after 10 hearing in the week commencing 20 November 2023. 20 November, you have a calendar there. Just
Yes.
look at the calendar.
18.
20 November, week commencing that. The medical record of the applicant is kept as a part of the file.
Lordship, I'm sorry, Lordship, I could not be on time as an I was in another.
Yes.
Here, this interlocutory application has come up for with a prayer for suspension of sentence and grant of bail. Here, the appellant is convicted under section 302 and 498A of IPC. I have given one compilation of evidence, Lordship, and the FIR. What I find subject to what my learned senior friend says, Lordship.
Last time you did.
Yes, Lordship.
Oh, yes.
Here, wife of the appellant, Lordship, died homicidal death. And at the initial point of time, he informed the police. Subsequently, father-in-law lost the case and he was arrested, and after the trial, he was convicted. He is convicted now. In the entire evidence, Lordship, I have not found any incriminating material which shows that the appellant was present in the house when the incident occurred. First, Because Lordship, to attract section 106, the first prosecution have to prove that I was present when the incident occurred. Then they can shift the burden on me, Lordship. In the entire evidence, there is no material to show that I was present. FIR, your Lordship will find page 2 of my compilation. Cases of circumstantial evidence. Only circumstance I find is that Lordship, he is husband of the deceased and victim died homicidal death. Apart from that, there is no material in the record.
Just one. So that's it. In division bench, we will not be able to take up any other matter. This will have to break for single bench. This is the only matter we'll take up. Other matters will be adjourned. Mr. Bhattacharya, if you are waiting for any division bench matter, then it will be adjourned today. Because there is a single bench we'll have to attend. After this, we'll be breaking up. If you have any, what is the matter? Next matter.
Single bench matter.
Single bench, then single bench shall be taken up. Okay, what are other submissions?
Here in this case, if your lordship see the evidence of PW1, his last 3 lines, lordship will find that on the day of incident, there was marriage party in the house. So it was not in a secrecy that the offense has committed. Last 2 lines, lordship will find PW1. On the day of incident, the marriage party of the younger brother of the accused was also going on in the house of the accused. Of examination in chief, lordship, last 2 lines. And then your lordship may kindly turn to the last part of the cross, lordship, last line of his cross examination of PW1. Prior to lodging of my FIR, the accused himself informed the police. So it is not a case that they were projecting that victim has committed suicide. They themselves have informed the police. Another factor also.
Yes.
And if your lordship turns to page 8, lordship, your lordship will find that it is the brother of the accused who informed the others, lordship. So there is nothing on record who first saw the deceased. And against brother of the accused, lordship, FR was submitted. He never faced trial, although he is named in the FIR. And in page 9, your lordship will find that she deposed that there was some dispute with the informant with the deceased, lordship, regarding some gold ornaments. That is a prosecution witness, and she is not declared hostile. And her conversation with the deceased is probable because this PW3 is also a lady, lordship. And other witnesses also said there was no quarrel, so I am not taking your lordship much time. Lordship may now kindly turn to the inquest report, page 23. Page 23. In column number 3, your lordship will find top portion, lordship, that place and time. Place is Kajaigaon PS campus. Dead body found trace 17/3/2018. Time, lordship may kindly noted that 10:30 AM.
Yes.
And now lordship may kindly turn to page 25.
Yes.
Yes, that date and hour, left column, from left fourth column top, Lordship will find 17/3/2018 at 10 a.m. I would not have stressed much here, but because there is a reason, Lordship will find page 26, time of date. Page 26, last Lordship table. In my opinion, death was due to asphyxia as a result of antemortem strangulation. Time since death 6 to 12 hours. And now examination, your Lordship, again I am taking your Lordship to page 25. That postmortem examination was conducted at 3:30 p.m.
3:30, yes.
So it would be Lordship morning 3 a.m. at base, last time. And as per FIR and from the evidence, the incident occurred at daytime 2 to 2:30. Here maximum time is given, maximum time is 12 hours. So that will be around 3:30 a.m.
What is the point you are trying to make?
Incident occurred on 16th at about 2 to 2:30. And as per postmortem, incident occurred after 3:30 a.m. on 17th. The dead body which they were sent and the dead body which they have examined, that is already in the Kazaigaon police station at 3:30. Time since date shows 6 to 12 hours. That will be from 3:30 p.m. when examination was done. Postmortem was conducted on the next day of our day. So it is what there in the record I have shown, and what is not there in the record is that, Lordship, the prosecution could not show that at the time of incident I was present in the house to shift the burden upon me, Lordship. And that regarding your Lordship will find page 20 and 21, paragraph 20 and 21, Lordship, of the judgment. May I read it?
You have anything to say?
Here, I want to rely on the FIR, Your Lordship, lodged by the father of the victim, Your Lordship. It's in Varnacula, it's a page 2, my lord. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মোৰ ছোৱালী নচিয়া খাতুন 28 বছৰ প্ৰায় 10 বছৰমান আগতে 1 নং আসামীৰ লগত বিবাহ হয় বৰ দুখৰ কথা এই যে প্ৰায় 7-8 বছৰ মানৰ পৰা যৌতুক দাবী কৰি আন আসামীৰ চক্ৰান্তত 1 নং আসামীয়ে মোৰ ছোৱালীক নানান অমানসিক অত্যাচাৰ কৰি আহিছে এনেকি প্ৰায় এসপ্তাহ মান আগতে মোৰ ছোৱালীজনীয়ে ফোনযোগে জনায় যে তাইৰ স্বামী তাৰ স্বামীয়ে 1 লাখ টকা বিচাৰিছে আৰু 2 দিনৰ ভিতৰতে উক্ত টকা আদায় দিব লাগিব এনেকৈ যোৱা 13 মাৰ্চ তাৰিখে 1 নং আসামীজনে মোৰ ছোৱালীক লগত লৈ উক্ত দাবীকৃত টকা বিচাৰি মোৰ ঘৰলৈ আহে কিন্তু বহু কষ্ট কৰি উক্ত টকা যোগাৰ কৰিব দিব নোৱাৰাত যোৱা 15 মাৰ্চত খালি হাতে হিহঁত গুচি যায় আৰু গুচি যাওঁতে 1 নং আসামীজনে বিভিন্ন অকথ্য কথাৰে গালি গালাজ পাৰে আৰু অতি সোনকালে তেওঁ মোৰ ছোৱালীক তালাক দিব বুলিও ধমক দি থৈ যায় এনেতে যোৱাকালি আবেলি 3:30 মান বজাত 3 নং আসামীজনে ফোনযোগে জনায় যে মোৰ ছোৱালীজনীয়ে ষ্ট্ৰোক হৈ মৃত্যুবৰণ কৰিছে মৃত্যুৰ খবৰ প্ৰায় ততাতৈয়াকৈ আমি 1 নং আসামী ঘৰলৈ যাওঁ আৰু ঘৰত শুৱাই থোৱা তাইৰ মৃতদেহ প্ৰত্যক্ষ কৰোঁ এনেকি মৃতদেহৰ বিভিন্ন স্থানত আঘাতৰ চিন দেখা যায় মৃতদেহৰ প্ৰত্যক্ষ কৰা আঘাত সমূহৰ প্ৰতি লক্ষ্য কৰি আমাৰ সন্দেহ যে আসামীসকলে পৰিকল্পিতভাৱে মোৰ ছোৱালীক হত্যা কৰিছে সেই মহোদয়ক প্ৰাৰ্থনা জনাও যাতে ঘটনা সংক্ৰান্তত গোচৰ পঞ্জীয়ন কৰি তদন্তক্ৰমে দোষী শাস্তি দিয়ে now I take your lordship to the evidence of PW1 my lord the informant at page 5 I am the complainant of this case the accused is my son-in-law the incident took place about 1 year ago about 10 years ago I gave marriage of my daughter with the accused and 2 children also were born out of their wedlock. Since their marriage, the accused used to torture my daughter demanding dowry and 2 days prior to the incident, my deceased daughter along with the accused came to our house and on that day also he demanded money. After staying 2 days in my house, she again returned to her matrimonial house. On the next day, the younger brother of the accused made contact my own younger brother at Meghalaya over telephone and informed that my daughter died out of stroke. After getting the information, I myself and some villagers went to the house of the accused and when I arrived there, I saw lots of people along with police officer of Kajigaon PS. When I inquired, the police officer told me that it was not a case of hanging, but it was a case of murder. I also marked blood was oozing out from the ear and also noticed scratch mark near to her mouth. I also shown the mobile recording of the police officer and told him that I was informed that my daughter died out of stroke. And then police officer refused and told me that it is a case of murder. Thereafter, I lodged the FIR against the accused and his brother-in-law, Bachu Sheikh, who was also involved behind the murder of my daughter. Apart from that, the mother and 2 brothers of the accused were also involved. On the day of the incident, the marriage party of the younger brother of the accused are also going on in the house of the accused. The house of the accused and my younger brother was still in the Meghalaya. On the day of cremation, my younger brother came from Meghalaya to attend the ceremony. My grandson is around 8 years, 6 months, and my granddaughter around 2 years of age. Within that period of 10 years, my daughter came to our house for Nair on several times, and in some occasion, the accused also accompanied my daughter. Though the accused used to demand money or dowry since the time of marriage, neither my daughter nor I had lost any case or any village bichar in the police station or court except the present one. After the 2 children, one was born in our house and other was born in the house of the accused. My grandson is staying in my house since the time of his birth. I also used to visit the house of the accused to meet my daughter and to see my granddaughter. Whenever I visited to the house of the accused, I had talked with my daughter. Lordship, the next line is relevant. On that day, also my daughter along with the accused and my granddaughter came to our house to attend the marriage of my son. But due to some unavoidable reason, the marriage was cancelled and hence my daughter was again returned back. The marriage was cancelled as my son, so that is not relevant. And your lordship, the next line is relevant because on the relevant day, the accused person was with the victim, your lordship. She came back from the house of her parents. And in next page, my lord, prior to the lodging of the FIR, the accused himself informed the police. So accused is very much present there, but he could not discharge his burden under 106. Under what circumstances the victim died, your lordship? Because as per the inquest report, as well as from the postmortem report, which could discern is that the hyoid bone was fractured, your lordship. It was a homicidal death. So, lordship, the presence of the accused person, since he informed the police, he could have taken the plea of alibi, your lordship. He was not there at the place of occurrence. Moreover, your lordship, they have given wrong information to the parents of the victim. The victim died out of stroke, my lord. Whereas as per the doctor's report, it is antemortem strangulation, my lord. That is my respectful submission. Since lordship, probably LCR has come. Paper book be prepared, your lordship. Nice, LCR. This one, no? Yes, sir.
What is the name of PW1?
PW1 is
PW1 is Nosad Ali.
Yes.
Lordship, since the LCR has arrived, may I pray your paper book be prepared? Benefit of, yes, my lord. Lordship will not allow the your lordship.
Examine it.
My lord.
There's a matter fixed, whether on Monday or Tuesday it is coming for delivery of orders.
I'm not getting a lordship's voice.
Matter is fixed either on Monday or Tuesday it is coming for delivery of orders.
Yes.
This also we are fixing on the
Yes.
same day.
Okay.
We just examine when it is
My lord.
being listed.
Lordship.
We have it listed on the same day.
Just one thing I'm quoting, Lordship. Even in page 14, your lordship will find that IO has stated, in the opinion of the witnesses, the police and the CO, the deceased might have died due to hanging. So initial, even police and IO was also on of that opinion.
Page 14.
Page 14. So therefore, the relatives of the page 14 cross examination of IO.
Because if you don't read, we will not remember.
That's it. Page 14, cross examination, 4th line. That's it.
Page 14.
Page 14. 4th line of cross, Lordship.
Lordship,
We are
he is not an
making-
expert. IO is
We
not
are
an
not making
expert.
a comment, but that is what we are wanting to say. Not that, but he did not see any ligature mark. That is why he is making that statement. But according to the medical opinion, the death was due to ligature strangulation.
That I'm not disputing at this stage, but the fact is that Lordship, whether prosecution was able to prove that I was there at the time of occurrence or not, that then Lordship 106 will come.
They are the inmates of the house, my lord.
So the marriage ceremony was going on.
Still then.
Or he was not alone with his wife, Lordship.
It
Marriage
is not-
ceremony was going on. It is admitted fact.
Every member of the family,
So
Lordship,
every member who attended the marriage, they cannot be booked under this section. Lordship.
they should have given explanation, my lord. Tuesday, 27.
Yeah. Comes for the applicant and his B. Bhuyal Arad, Senior Counsel in ABP for the state. Argument in this interrogative application is concluded. List on so for delivery of orders.
On 26/9, my lord. Tuesday.
You check it out.
Yes.
I mean, Monday or Tuesday, I don't know. The court master will check it up
My
and
lord.
clear it.
Offline.
It is a Lordship. Lordship, as per last order dated, I have served the copy matter to the earlier engaged counsel representing the petitioner. Today I am praying for a short adjournment matter. On behalf of my senior Mr. H.R. Chaudhary matter. Yes, left the court due to some personal.
Put up next week.
Can it be on 4th of October, man? Next week.
4th of October.
Fourth.
Okay. both sides are represented. On the prayer made by Mr. M.H. Chaudhary, counsel for the petitioner, list on 4/10/2023. Wakatma is not required.
Their
You will
name
file-
may be reflected, my lord, otherwise.
Oh, okay. The-
Yes, Pony, my learned senior, my learned friend is also there.
Okay. The registry shall reflect the name of Mr. No, your senior's name?
Yes, Pony.
S.
Yes, Bonik.
Banik, S. Banik and Miss A.N. Hussain as counsel for the respondent of the great petitioner while listing the matter next. Yes.
Good. Is there an interim?
Oh, actually,
Immediately after first week, my lord, what has happened, my lord, before making the mention, my lord, we made a request before the registry, my lord.
Okay.
To list the matter. Accordingly, basing on that, our representation, my lord, today it
Okay,
has been listed.
Okay.
And I has to file.
Below the Supreme Court state the proceeding.
Mr. Bhattacharya, I don't know whether you have been briefed or not. What had happened was day before yesterday.
Yes,
When it
sir.
was mentioned day before yesterday.
I have informed. you.
Okay. So Mr. K.P. Pathak, senior counsel who appears for the respondent, he will be out of station. He agreed to a date of 3rd of
October.
October.
3rd
Can
of
we fix it
October.
on that day? If it is not inconvenient to you.
No, it will not be inconvenient. But only thing I want to point out, this proceeding is going very slowly. Ordinarily under the law, my lord, preferably it should be disposed of
But Supreme Court
within
has
6
stayed the
months.
proceeding.
And they have not filed even the written statement till today.
Supreme Court has stayed it. We can't.
No, my lord, the Supreme Court has vacated this.
It's vacated. Okay.
Your
Where is the
lordship
order?
would like to see that order.
Yes, yes.
My lord, first your lordship may kindly see page 24.
Yes,
This is your lordship's order.
yes.
Heard so and so, assisted by so and so. Also heard Mr. A.G. Choudhury. By filing this interlocutory application, the order dated 18/5/2000 passed by the Supreme Court of India in petition for special case number so and so by which the proceeding when a stay is brought on record. Accordingly, this matter is adjourned signed. The learned counsel for the petitioner shall apprise the court of the outcome of the SLP.
Yes.
SLP has not been disposed of, but the order of staying the proceeding has been.
You show it to Mr. Acharya. Show it to the senior counsel.
Your lordship may kindly come to page 15.
16.
Yes, this was the order of the Supreme Court.
Yes.
Page 15.
Page 15.
Yes.
Further proceedings in election petition number so and so pending in the Guwahati High Court shall remain stay until the next date of hearing. Then your lordship may kindly. Other orders are not very important. you know. No. Okay. Then, my lord, page
14.
Okay, you're trying to
Page
say that
60.
the next orders, the stay was not continuing. That is what you want to say.
Yes.
We consider that, we'll fix it on the day, since Mr. Pathak is out of station. we
No,
can
that
work
is
it
all
with the
right, my lord. Your lordship can fix on third. But only thing I am making a prayer before your lordship. As far as practicable, it should be. my lord.
I will consider that definitely.
Yes, that.
Once it is clear. Third. Mr. A.K. Bhattacharya, Senior Counsel, assisted by Mr. A.R. Punia, Counsel for the applicant. Mr. H.I. Chaudhary, Counsel for the respondent number 1. Has made a prayer for adjournment on the ground that Mr. K.P. Pathak, Senior Counsel, for the respondent is out of session. And it please that the matter be taken up on 3/10/2023. What we pray for adjournment is allowed. List on 3/10/2023. So, Bhattacharya, how's your health?
Yes. I'm keeping well now.
It's okay.
Though I am not coming every day. Whenever case is listed, I come.
Oh, it's okay. That much of liberty you will always take.